Breaking news. A federal judge just struck down Illinois' assault weapon ban, declaring it unconstitutional. And now the Seventh Circuit is fast-tracking an appeal that could send this straight to the Supreme Court. The most popular rifle in America, the AR-15, owned by over 24 million Americans, just won a massive victory in federal court. But Illinois is fighting back, and what happens in the next few months will either restore gun rights nationwide or give every state the power to ban these firearms permanently. Justice Clarence Thomas already said the Supreme Court must address this issue. Justice Brett Kavanaugh promised the court would take up an assault weapon ban case within a term or two. The question is, will they keep that promise or break it? Hit subscribe and turn on notifications right now, because this case is moving fast and you need to know what happens next. What just happened in Illinois? The case is called Harrell versus Raoul, and it just delivered a massive win for gun rights. On November 8, 2024, Federal District Judge Stephen McGlynn issued a 168-page ruling declaring Illinois' Protect Illinois Communities Act unconstitutional. This law, signed by Governor J.B. Pritzker in January 2023, made it a felony to possess what Illinois calls assault weapons. We're talking about over 100 specific rifles banned by name, including the AR-15 and AK-47. The law also bans firearms based on cosmetic features like pistol grips, folding stocks, and threaded barrels. Judge McGlynn conducted a full bench trial with witness testimony and over 10,000 pages of evidence. His conclusion: the ban violates the Second Amendment. He permanently enjoined Illinois from enforcing the law. But here's the catch. He stayed his own injunction for 30 days to allow Illinois to appeal. And they did, immediately. The state filed an emergency appeal with the Seventh Circuit, and that appeal is being heard right now as we speak. Now here's why this moment is absolutely critical and different from every other gun case in recent years. Justice Brett Kavanaugh made a public promise. After the Supreme Court denied review in a case called Snope versus Brown, Justice Kavanaugh wrote a statement saying the court would likely address assault weapon bans within a term or two. Justice Clarence Thomas has been even more direct. In his statement on the Harrell case when the Supreme Court initially declined to hear it in July 2024, Thomas wrote that the court must provide guidance on which weapons the Second Amendment covers. He specifically said if the Seventh Circuit allows Illinois to ban America's most common civilian rifle, the Supreme Court can and should review that decision. We're about to find out if those were real promises or just empty words. Background. The battle so far. Illinois passed this ban immediately after the Highland Park mass shooting during a 4th of July parade in 2022. Governor Pritzker signed it in January 2023, and gun rights organizations filed lawsuits within days. The Firearms Policy Coalition, Second Amendment Foundation, and Illinois State Rifle Association joined gun store owner Dane Harrell in challenging the law. The case took a dramatic turn in April 2023 when Judge McGlynn initially granted a preliminary injunction, blocking enforcement of the ban. Gun owners celebrated what became known as Liberty Week, a brief period when they could legally purchase these firearms again. But Illinois immediately appealed to the Seventh Circuit, which overturned Judge McGlynn's preliminary injunction and allowed the ban to continue while the case proceeded. The Seventh Circuit's reasoning? They claimed AR-15s are too militaristic and too similar to military M16 rifles. According to their logic, if a firearm is useful in military service, states can ban it even if millions of law-abiding citizens own it. Gun rights advocates asked the Supreme Court to intervene in February 2024, but the court declined in July 2024. Only Justice Alito voted to hear the case. However, Justice Thomas wrote a powerful statement saying the court should, and eventually will, address this issue when the cases reach final judgment. That's exactly where we are now. Judge McGlynn held a multi-day trial in September and October 2024, heard all the evidence, and issued his final ruling on November 8th. This isn't a preliminary decision anymore. This is a final judgment on the merits, and it completely rejects the Seventh Circuit's reasoning. Why the district court ruling matters. Judge McGlynn's decision is devastating to Illinois' arguments. He found that AR-15s and similar rifles are unquestionably arms protected by the Second Amendment under the Supreme Court's Heller and Bruin decisions. He rejected the Seventh Circuit's military usefulness test as having no basis in Supreme Court precedent or American history. In fact, Judge McGlynn pointed out that historically, Americans had the right to own arms suitable for militia service, which would include military-capable weapons by definition. The court found that over 24 million AR-15-style rifles exist in America, making them the most popular rifle platform in the country. They're used for home defense, sporting competitions, hunting, and recreational shooting. These are firearms in common use for lawful purposes, which under Heller means they receive full Second Amendment protection. Judge McGlynn also found that Illinois failed to prove any historical tradition supporting a ban on these types of firearms. The state couldn't point to any analogous laws from the founding era or the 19th century that banned commonly owned arms. But Illinois isn't giving up. The state immediately appealed to the Seventh Circuit and requested an emergency stay. On November 11th, the Seventh Circuit granted that stay, meaning the ban remains in effect while the appeal proceeds. Illinois gun owners had hoped December 9th would mark the end of the 30-day stay and the beginning of restored rights. But the Seventh Circuit's emergency stay dashed those hopes. What happens next? The path to SCOTUS. Here's the timeline that matters. The Seventh Circuit is now considering Illinois' appeal. Based on the expedited nature of the stay request, this case is moving much faster than typical appeals. We could see a ruling from the Seventh Circuit within months, possibly by early 2025. Whatever the Seventh Circuit decides, this case is almost certainly heading back to the Supreme Court. And this time, the circumstances are completely different. When gun rights groups petitioned the Supreme Court in February 2024, they were appealing a preliminary ruling. The Supreme Court traditionally avoids interlocutory appeals, cases that haven't reached final judgment. That's likely why they denied review in July. But Judge McGlynn's November ruling is a final judgment. The Supreme Court specifically said through Justice Thomas that they should review this issue once the cases reach a final judgment. Well, it has reached final judgment now. If the Seventh Circuit reverses Judge McGlynn and upholds Illinois' ban, gun rights organizations will petition the Supreme Court again immediately. This time, with a full trial record, expert testimony, 10,000 pages of evidence, and a district court ruling declaring the ban unconstitutional, the Supreme Court will have everything it needs to grant review. And here's the critical factor. Justice Kavanaugh promised the court would address this issue. Justice Thomas has made it clear he believes the court must intervene. If the Seventh Circuit upholds the ban, we'll see if those justices' words actually mean anything. The moment of truth. This isn't just about Illinois. 9 states have comprehensive assault weapon bans: California, New York, New Jersey, Connecticut, Massachusetts, Maryland, Delaware, Washington, and Colorado. Tens of millions of Americans live under these restrictions. If the Supreme Court ultimately rules these bans unconstitutional, every one of those state laws falls simultaneously. Gun rights would be restored across nearly a quarter of the country overnight. But if the Supreme Court refuses to intervene, if they deny review again or uphold these bans, it signals open season for any state legislature that wants to pass similar restrictions. States like Michigan, Minnesota, Pennsylvania, Nevada, and Arizona that currently don't have bans but have Democratic majorities could move quickly to enact them. We could see half the country under assault weapon bans within a few years. And here's what makes this case the ultimate test of the Supreme Court's integrity. When Justice Kavanaugh said the court would address assault weapon bans in a term or two, was that a genuine commitment or just words? When Justice Thomas wrote that the court can and should review this issue at final judgment, did he mean it? We're about to find out. The Seventh Circuit will rule in the coming months. If they uphold the ban, the Supreme Court will face a critical decision: grant review and finally resolve this issue as promised, or deny review again and prove those statements were meaningless. Conclusion: this case is moving faster than any assault weapon ban challenge we've seen. Judge McGlynn's November ruling changed everything. We now have a final judgment declaring these bans unconstitutional. The Seventh Circuit is considering Illinois' appeal right now, and whatever they decide will likely send this case back to the Supreme Court. The next few months will determine whether 24 million AR-15 owners retain their constitutional rights or become criminals overnight. So here's my question for you. Do you think the Supreme Court will keep Justice Kavanaugh's promise and take this case, or will they deny review again? Drop your prediction in the comments below.